All right, this is 25 CF 2253 State versus Keith Jones, and the appearances are.
The state appears by Assistant District Attorney Thomas Valerio.
Mr. Jones appears in person and with Attorney Sean O'Connell. We've received a copy of the criminal complaint, waive its reading. The address should be updated to be the Dane County Jail. Mr. Jones is eligible for representation through the Public Defender's Office.
All right. Attorney O'Connell, this is also a UW police case. Mr. Jones, my son's an officer with UW Madison Police Department who was not involved in the investigation in this case. My understanding was the most he might have done is set a perimeter down by Breeze and University, and that was it. Would you like me to find another commissioner to come do the bond hearing today, or are you satisfied with that I can proceed today?
I could have one moment. Mr. Jones says that's fine and we can proceed with you.
Okay. Okay. All right. I did have a chance to review the criminal complaint previously, and I do find there is probable cause to proceed. Attorney Valerio, what's the state's request regarding bond?
I'm asking for a $1 million cash bond in this case. I'm asking that the defendant have no contact with the following individuals: CLT, KAT, and KKT. For the record, those are the family members of Mark T, the victim in this case. I would ask that the defendant be banned from the UW campus as that's outlined in our ban map, and that the defendant be referred to pretrial services for GPS monitoring to enforce that ban. And I would ask that he not be released from the Dane County Jail until he's equipped with that pretrial servicing monitor. Furthermore, I would ask that the defendant have no contact with any BEST employee or any UW athletic employee, and that the defendant not use or possess any dangerous weapon as that's defined by the Wisconsin statutes. So, Commissioner, this what I can just tell you from the outset is that Mr. Jones doesn't have any recent failures to appear that I can make you aware of. But this is the most serious offense that one can commit in the state of Wisconsin, and it's certainly an Act 3 eligible offense. So in line with that, I'll inform you that Mr. Jones was previously convicted of aggravated battery, which was amended from a homicide-related charge on April 24th, 1995 in Racine County, case number 95 CF 92. Mr. Jones on that same day was convicted of escape/criminal arrest in Racine County, case number 95 CF 348. For those offenses, Mr. Jones was ordered to serve 5 years in prison. And then in 2009, February of that year, Mr. Jones was convicted of armed robbery in Grant County, case number 08 CF 141. There, he was sentenced to 6 years of initial confinement and 11 years of extended supervision. While he was on extended supervision for that case, he was convicted of substantial battery on March 27, 2018 in Grant County, case number 17 CF 227, where he was sentenced to 1 in, 1 out. And this case occurs while Mr. Jones is on extended supervision. So as you can tell from the facts in the criminal complaint, a lot of the sort of description of how the offense occurred is referenced on the top of page 3 under the section of reviewing surveillance footage. And on there, it's noted that Mr. Jones is on surveillance footage repeatedly battering MAT in lot 19. The defendant, while wearing a white hockey mask over his face, approaches MAT in the lot with a hammer in his right hand and swings that hammer at MAT's head. Surveillance footage shows MAT falling to the ground, appearing unconscious, and while he's on his right side appearing unconscious, Mr. Jones proceeds to stomp on MAT's head. According to the complaint, that occurs 7 times. And law enforcement makes note that one of the stomps was so forceful that Mr. Jones lost his balance. Law enforcement continues to note how Mr. Jones raises his left leg to his chest to more forcefully stomp on MAT's head. Preliminary findings from the medical examiner's office indicated blunt force trauma to MAT's head, and Mr. Jones indicates that he had indicates, quote, everything that happened in the video, I did it, end quote. To substantiate sort of the no contact with the athletics department and best employees, it's also mentioned in the criminal complaint that a director management from UW Athletics told law enforcement that MAT, along with Mr. Jones, both worked for best security at Camp Randall. He indicated that they both didn't get along. That director indicated how the defendant and victim argued over a particular shift that needed to be staffed during the Badgers versus Middle Tennessee football game that happened about 2 weeks before the incident. It was reported that Mr. Jones was reportedly mad at the victim for having that shift that the defendant wanted, and the defendant also said he was fed up with former CSC staff who joined Best Security, saying that that staff didn't respect best employees or something to that effect. That might also tie into some of the motive involved in this case. Nevertheless, if we were looking at this pre-Act 3, this is probably a case where we would nonetheless order $1 million because of the mere fact that Mr. Jones committed this offense while he was on extended supervision. It's even more the case now that Act 3 is in play. He has previous Act 3 eligible offenses for which he's been convicted. He committed this offense while he's on extended supervision. I think that the particular victims in this case certainly need protection, given the possible motivations for why Mr. Jones allegedly committed this offense. And I do think that the general public at large certainly needs protection in this case. So I do think that the requested bail is appropriate.
Attorney O'Connell?
So I'm aware that there's going to be a large amount of cash ordered. I'll just, I guess I'm not going to argue that point. It seems kind of moot. I do think the request for no contact with best employees or UW Athletic, I don't think that there's a sound basis for that. It doesn't appear that Mr. Jones has threatened or intimidated or tried to do anything of that nature to any of them. So I'd ask that you not order those conditions. Otherwise, I don't have any further argument.
Okay, thank you. Based upon Act 3, the offense itself, as Attorney Valerio points out, probably even before Act 3, probably would have been a very high cash bond regardless, because it's a life crime. There's a good incentive not to appear at future court dates, and the fact that you are on status at the time of the offense on ES would suggest also not taking the seriousness of community corrections to the extent that it should be. But with Act 3, there are certain other factors I can consider: protection to the public, protection to the victim or victim's family. I think no contacts with the victim's family appear to be appropriate, though I don't know if this was directed to this person or the family as much as it sounds like it was a beef potentially with best security, maybe with the individual as well. But I think no contact with the family is appropriate if it will assist them in hopefully feel at least less concerned if you were released, and would try to take it out on them. Not saying you would, but I think the request does appear to be reasonable related to the offense. The ban on UW campus, I think, is an appropriate ban. And if you were released from jail on the cash bond that I'm going to set in a moment, GPS monitoring would be ordered before you could be released from the jail. Now, I think the UW campus ban should cover the athletic department as well, so I'm not that concerned. But I'm going to order specifically no contact with best security or any of their employees. I think that's separate. And I think it is a valid concern based upon my reading of the complaint and the Attorney Valerio's summarizing of the complaint just now. I'll also order no dangerous weapons. I think in light of the prior history your prior record and the prior history in this case, as well as the fact that you were on ES at the time for aggravated offense, I think $1 million cash isn't out of the realm of unreasonable. So I'm going to order $1 million cash bond at this time. And the matter would be set for a preliminary hearing, which you have the right to have held within 10 days, and we'll schedule it within 10. Unless there's some issues that come up with you and your attorney, you need more time, that's fine. But for now, we'll schedule it on the calendar with the judge for 10 days from today, okay? All right, good luck.
Next is Joshua Yanis.